following urgent announcement is the official State of the Nation address for the Republic of South Africa for 2017. I decree by the power vested in me as State President-elect Wilna Minnies for the Republic of South Africa as the leader of South African Federal Union Political Party, abbreviated as SAFU, which political party I registered on the 23rd of January 2004. The registration was advertised in terms of the provisions of the Law Act 51 of 1996, the Independent Electoral Commission Act, with regard to registration of parties, and advertised in the Government Gazette of 30 January 2004, legal notices issue 25994, volume 463. I decree as follows, that the Republic of South Africa is a state of emergency, following not only the guilty verdicts handed down against President Jacob Zuma as the collective for the entire African National Congress, ANC, including Parliament, which are all the opposition political parties and their office bearers. They were found guilty and thus not have the excuse of innocent until proven guilty in the court of law. The International Criminal Court at The Hague in the Netherlands passed a guilty verdict against all of them. A second time, the Constitutional Court at Constitution Hill Braamfontein, Johannesburg, Gauteng, Republic of South Africa, the highest court in South Africa, also handed down a guilty verdict against them all. Regardless of how many times they will jump ship and form other political parties, they lack the power to act and therefore cannot do any official state businesses. Therefore, the motion of no confidence tabled before Parliament from the 9th day of February 2004, before Parliament and the Constitutional Courts, is a situation that none of them have the authority to vote and debate upon. This motion of no confidence was then tabled by myself last year, the 1st and the 2nd of February 2016 at Gandhi Square in Johannesburg before South African citizens who seconded the motion of no confidence, thereby fulfilling their civic duties in terms of the Constitution of the Republic of South Africa, which is Act number 108 of 1996. What is the irony at the moment is that all members of Parliament pretend to be ignorant of the legal consequences of their actions. Going back to 9 February 2004, the African National Congress, ex-President Thabo Mbeki, in consultation with its executive and the late President Mandela, instructed the executive board of the IEC, the Independent Electoral Commission, Dr. Brigalia Ben and others, and Advocate Tlakula Pantsi, to cancel the registration of South African Federal Union Political Party by the retrospective application of an unlawful banning order called Act Number 13 of 2004. This Act Number 14 is invalid on many grounds. It was adopted, firstly, during recess of Parliament, and secondly, it was applied retrospectively to make it a criminal offense for me to claim fulfillment of my fundamental human rights entitlements. Everyone in Parliament were fully aware of the legal consequences of the violation of the Constitution of the Republic of South Africa. This is the Constitution of the Republic of South Africa. My Constitution and yours. Everyone in the country knows that during CODESA 1 and CODESA 2, I was not a part of the multi-party debates and scrutiny of the Constitution before it was adopted. And so therefore, I was not able to entrap any of the members of Parliament. I was not aware of the notorious Arms Bill of 1999. At that stage, I felt that I was being punished for being a God-fearing, law-abiding South African citizen. Prior to that date, I applied to the state for concession for school fees that are owed for my son at a private school run tutorial college. Because my son was constantly intimidated and put out of the school, I approached the school, knowing full well that they proceeded to do the application to the state for help. I felt my son suffered, his esteem was attacked, self-esteem, and he lost valuable time in class. Therefore, I offered to work for the school fees I owed, which was 1,003 rand. The school agreed. In 3 days, the debt I owed the school was settled. The school approached me, the principal, and said, my educator, Miss Zelda Ace, at that stage, went through an operation, she cannot come back. Will you work? I agreed, and therefore worked for 3 months, while my sister, Mrs. Carrington, also paid for the same debt, 1,500 rand. The state gave me 8,000 rand for 1,003 rand. What I did was approach the auditing department in the education department and said, thank you very much for the help of the state. But I settled the debt, make sure the school returned this money, and if you could help me next year, 2004, I would be grateful. 2002, 2003. Members in Parliament became aware of the fact that I act as a responsible South African citizen, and I felt that I was being discriminated because of that, not knowing about the notorious arms deal of 1999. I am not grinding an axe. What is happening at the moment is, because of the anarchy, the lawlessness of all these members, the entire country faced disaster. They were fully aware that and is fully aware that they cannot, may not act, may not receive the benefits of the office, but continually refuse to do what they know they ought to do, to resign from public office and tell the nation the truth. They knew what democracy meant. Leadership by the people, for the people. The operative words of democracy is with the consent of the people. The people who they warned that if they injured any one South African citizen, the consequence would mean they injure themselves. This is clarified in Section 36 in the Bill of Rights of Chapter 2 of the Constitution of the Republic of South Africa, that reads that the limitation of the right in the Bill of Rights must be done by law of general application only. It must be reasonable and justifiable in an open democratic society based on dignity, equality, and freedom, taking in account the nature of the rights. In my case, all my fundamental rights were altogether negated. I'm denied access to the courts. All organs are working together to deny my fundamental rights. Education, health, social services, the judiciary, legal aid, human rights attorneys, Section 27, legal resources, human rights commissioners, public protector, gender equality, state attorney, national prosecuting authority, including police officers. I know that certain of the police officers are members of parliament masquerading, not only as police officers, but also as judges, magistrates, commissioners. This means they are continually, with the assistance of big state members and foreign nationals, and the Guptas intentionally use their mind and intelligence to commit crimes against the state, which is high treason, sedition, public violence. They commit crimes against the administration of justice, contempt of Parliament, contempt of the Constitution, contempt of the court orders and the courts. They commit crimes against the administration of justice, which is they are obstructing and defeating the ends of justice by pretending to be judges, magistrates, police officers, national prosecuting authorities, state attorneys, and so forth. They are committing perjury. Add to this the disastrous result of the 4 men murdered on the Americana. The 2 men murdered 26 March 2004 at Steinheis Parliament when the Secretary General of the United Nations came to the Republic of South Africa on my request. And in the presence of late President Mandela and the entire executive of the African National Congress, these men were murdered in cold blood. This was never investigated. Add to this the hundreds of young men taken out of the street as soldiers, not properly trained and sent to neighboring states to go and overthrow governments, to create a safe path for members of parliament. The recent disaster of 94 psychiatric patients murdered. Do not forget about the 30 girls, orphan children they were claimed, who were burned alive in Durban in South Africa.